Mediation is a great day. Really, nothing bad can happen in mediation. I have heard statistics that as many as 85% or more of all personal injury lawsuits get settled at a mediation. In my experience, probably another anywhere from 10 to 11% settle between a mediation and a trial, and probably only 3 to 4% of personal injury cases actually go all the way to trial. There are a lot of practical reasons for that, but I want to talk to you about mediation. Mediation is a process where plaintiffs' attorneys like myself, our clients, the defense attorneys' clients, which are usually insurance adjusters, and an approved mediator, usually a court-approved mediator, all spend either an entire morning or an entire afternoon together with a singular purpose of trying to resolve that specific case. The way a mediation works, the mediator doesn't have any actual authority. Mediator's not a judge, can't force our client to accept a certain amount of money, can't force the insurance company to pay a certain amount of money. But the mediator uses his or her many, many years of experience to try to work with the sides to reach some type of settlement agreement that makes sense for both sides. Usually mediations begin with the mediator explaining the ground rules of a mediation. Really, the most important thing to remember about a mediation is that whatever is said at the mediation is confidential, which means if the mediation does not result in a settlement and the case does proceed toward a trial, neither side is allowed to tell the judge or the jury about anything that happened or was said at the mediation. After the mediator speaks, then I get my turn, the plaintiff's attorney. We get to give a brief outline of the case from our point of view. It's not like the opening statement that we would give in court. Typical courtroom opening statement in a trial may be anywhere from 45 minutes to an hour and a half. Mediation opening statement is usually in a range of 10 to 15 minutes, and we just want to highlight the important factors of the case from our point of view to educate the mediator about the most important facets of the case. After I speak, then the defense attorney gets to speak, and they get to share the defense perspective, outlining the case from their point of view. I always take, and I encourage my clients to take copious notes during the defense presentation. What we're going to learn from them, regardless of whether the mediation results in a settlement or not, we're going to learn how they strategically plan to try the case. So it's fantastic. I love to hear all of the arguments and defenses they plan to make at trial so that if we do proceed to trial, I'm better prepared. That part of the mediation is always the most challenging part of the mediation for our clients. Clients have to just bite their tongue, resist the temptation to interrupt the defense attorney, correct the defense attorney, just have to sit there and take notes. You're going to hear the defense attorney misstate facts, mischaracterize facts, flat out get things wrong. You just have to let them say their piece. After the defense attorney speaks, then the two sides are separated into different rooms. And frankly, we won't see the other side anymore for the rest of the morning or the rest of the afternoon. The mediator begins meeting with each side in private, taking offers, counteroffers, back and forth between the rooms. A lot of the mediations that we're in will start up here, the defense will start way down here, and will gradually move with offers and counteroffers, and either we'll meet somewhere in the middle, or one side will say, no, we're not moving anymore. If you don't like it, let's just declare an impasse and let's proceed towards trial. So that's a very loose outline of what to expect at a mediation. There are a lot of strategies that go into negotiating a top settlement for a client. And we have decades of experience doing this. This is one of my favorite parts of any lawsuit. I tell my clients their one job during the mediation is to keep a poker face and treat the entire mediation as the serious event that it is. This is their opportunity. Nothing bad can happen. The other side's coming to offer money. The only question is it enough? And if it's not enough, no harm, no foul. We just continue moving on with the lawsuit and we haven't lost anything. Hope that answers your questions. I'm always happy to answer more of your questions if you have any. Check out our full website at trialpro.com, and you're welcome to call us anytime at 1-800-TRIAL-PRO. Thank you.